Aloha. Welcome to Abe Lease Seminars sessions. This session, we're going to talk about short-term leases. And what types of leases are there? Well, it depends on whether you're renting a single family or a condominium rental versus if you're renting an office space. So we're going to cover both of them in this session. So lease agreement is between the landlord, the lessor, and the tenant, the lessee. And the tenant doesn't own the property. They just have the right to rent the space and make sure that they follow the rules and the house rules and follow the law. So they don't do anything illegal. And the lease will give the tenant the right to use the property for a definite period of time. And what they call consideration is the payment of rent. So the landlord will say, I'm renting this out for X number of dollars per square foot. That's the base rent. And they're going to have what they call a common area maintenance, which is what they call CAM. CAM can be almost as much as the base rent because the CAM includes insurance, maintenance, supplies, security, repairs, and that type. In a lease, it's a contract and a conveyance. Well, what are they conveying? They're conveying the right to use that land or that office space for a number of years at a set rate. And so they call it a conveyance, called a demise in legal language, and it's transferring the right to use that property under certain guidelines and rules and regulations that the tenant must follow. Okay, leases can be short duration, could be a month, could be years. And as I mentioned, it could be a 55-year lease with a landowner, where the developer would then build an apartment building or an office building and lease that land for that time period. If the lease is less than a year, it can be verbal, but we don't recommend that. We always recommend, no matter how short the time period, you always have it in writing. Because if you have it verbal, how do you remember how much down deposit you put down? And how much was the rent? When did it start? What was the date? So we recommend always to have it in writing, even though by law, if it's a lease of less than a year, it can be a verbal lease. We don't recommend that. All right? Tenancy or the rents, they have 4 different categories. One is called tenancy for years, or what they also call it, estate for years. And the tenancy for years is the most common type of lease, but it's a misnomer. Because if you could have a lease for 6 months, they still call it estate for years. And you go, well, it's not for years, it's only for 6 months. So even though it could be 3 months, 6 months, 9 months, 10 years, 20 years, they still call it estate for years. And the biggest indicator of whether it's an estate for years is you have a start date and you have an end date. So let's say you're going to rent a house for a year. It starts on January 1, ends on December 31st. The end period is December 31st. So you have a set end period. That's what an estate for years has. You have a start date and an end date. And then if the tenant remains in the property with the landlord's consent after the expiration of the lease, say, let's say it's December 31st, and tenant says, hey, can I stay longer? And all the terms of the conditions of the original lease can be continued during this holdover period. And they can go extended for another year or go month to month. So that's estate for years. Now, these next 2, we don't use very often, but it's around because there are some instances where you need to have a different type of lease rather than tenancy for years. So it's called a periodic tenancy. Periodic tenancy exists when there's a specific time from period to period, week to week, month to month, year to year, but there's no end date. And it's created by a lease signed by the lessee, okay, and usually the lessor, but there's no specific termination date. It continues until one of the parties gives a notice of termination, and they have to give advance notice. So let's say you're on a month-to-month, or you're in a month-to-month lease for an apartment or a house that you're renting. It's a residence. What you can do then, okay, is a tenant will say, hey, I'm on a month-to-month and I'm leaving. The tenant can give a 28-day notice to vacate, and the tenant has to pay the full 28 days of rent because the tenant gave the notice to basically vacate. If the landlord gives a notice for the tenant to leave, then the landlord has to give a 45-day notice in writing to terminate. And if the tenant leaves on the 10th day, the tenant only pays for 10 days. He doesn't pay for the full 45 days. But if the tenant gives a notice, then he has to give a 28-day notice, and he has to pay for the full 28 days, even if he leaves on the 10th or 14th day. So there's a difference on what you're obligated to pay if in a residential landlord-tenant code in a periodic tenancy. Now, if it's a non-residential lease, it says the notice of termination has to be given 25 days preceding the end of any rental period or full rental period if the such period is less than 25 days, but with a 10-day minimum. That's a little complicated, isn't it? All right. And if the tenant retains possession of the premises after the expiration, a new tenancy can be created at the landlord's option for additional like periods. And if there's a failure to pay rent, or there's a breach of conditions that the tenant did not follow the rules and regulations, then the landlord can kick them out and give them what they call a 10-day notice to quit. That means you got to leave. And the landlord has to give you a 10-day notice of default. So that's periodic tenancy. Tenancy at will is different. And it says that the tenant has all the rights and privileges of a regular lease, but the tenant can stay there until the property is sold. Maybe the property is for sale. Or the owner of the land is applying for building permits to build a new building. So until the building permit is issued, the tenant can stay there. So it depends on some event occurring, a sale or permit. And it also says that the tenancy at will is the only lease that can be terminated by the sale of the property or death of either of the parties. Okay, and tenancy at will is also called the holdover tenancy. We don't see too many periodic tenancies or tenancy at will. And the last tenancy is called tenancy at sufferance. Now, if you think about the word sufferance, what it means is a lease is over, tenant has not left, and he's still there. And the landlord doesn't want him there. So the landlord says, you got to go. Tenant says, I don't have any place to go. Or can I stay longer? So really the tenant is there illegally against the wishes of the landlord. So that's called tenancy at sufferance. And there is no notice required to quit because there is no lease anymore, right? So in that case, the landlord is letting the tenant stay there, but he really wants him out. So the landlord can evict the tenant. But if the landlord takes a check and says, okay, I'm going to cash it, then they started a month-to-month tenancy. So these are all the rules that you have to know as a landlord to make sure that you're in compliance with the rules and regulations of residential landlord-tenant code or commercial laws. And by the way, commercial laws have no laws. It's usually negotiated. Whereas with the residential landlord-tenant code, there's specific rules that the landlords and the tenants have to follow. So hopefully it helps you to understand what the four types are. Okay, one is called tenancy for years or estate for years. Second one is periodic tenancy. And the third is tenancy at will. And the fourth is tenancy at sufferance. Hope this helps. Aloha.